The courtroom was silent, but the argument echoing inside it was ancient. Can you own what makes a human human? In the 1990s, as microscopes hummed and fluorescent lights flickered over lab benches, scientists raced through strands of DNA like explorers mapping an invisible continent. Each discovery felt electric. Each gene promised cures, profits, and prestige. But as the Human Genome Project surged forward, a darker question crept in behind the breakthroughs. Who gets to claim the map? Patents began to pile up. Companies staked legal flags on isolated genes, locking them behind paperwork and price tags. One firm, Myriad Genetics, patented the BRCA genes, mutations linked to breast and ovarian cancer. Suddenly, a woman's test, a doctor's second opinion, even independent research all required permission. The molecule inside the body became a commodity. Patients felt it first. High test costs, limited access, families waiting, anxious, wondering if knowledge about their own bodies was being rationed. Scientists felt it next. Research slowed, labs hesitated, discovery fenced in by legal boundaries. And the public began to ask a question that felt unsettlingly personal. If a gene can be owned, where does that leave the rest of us? The tension built quietly, then snapped. Lawsuits followed. Advocacy groups stepped forward. Scientists testified. In packed courtrooms, lawyers argued over whether isolating a gene made it an invention, or whether DNA, no matter how extracted, was still a product of nature. The climax came in 2013, when the U.S. Supreme Court delivered its verdict. Naturally occurring human genes, they ruled, could not be patented. You could discover them, you could study them, but you could not own them. The reaction rippled outward. Patients gained broader access to testing. Researchers breathed easier. The biotech industry recalibrated, shifting focus toward engineered DNA and new methods rather than nature itself. The ruling didn't end debate, but it drew a line. Because this fight was never just about science or profit. It was about identity, about whether the code written into every cell at birth belongs to corporations or to humanity. And in that quiet courtroom with no machines humming and no microscopes glowing, the law finally acknowledged something profound. Discovery does not equal ownership. Some things, like the blueprint of life, are meant to be shared. If this story sparked your curiosity, help the channel grow by liking, sharing, and subscribing.